Get ready. 3 seconds. 2 seconds. Start. The applicant filed a complaint under Section 138 of the Negotiable Instruments Act against respondent number 2 on 7/10/2002. Full stop. The verification of the complainant was recorded on 18/8/2003. Full stop. Process was issued thereafter on 8/12/2003 against respondent number 2. Full stop. The applicant filed an affidavit in lieu of examination in chief on 2/4/2004. Full stop. On 13/10/2005, the respondent number 2 preferred an application before the Metropolitan Magistrate praying for an acquittal on the ground that the affidavit of evidence was not affirmed and because it was not appended with a verification clause. Full stop. This application was rejected on 2/5/2006. Full stop. The applicant then moved the court for a de novo trial so as to enable him to file a fresh affidavit of evidence with the verification clause in order to cure the defect in the affidavit. Full stop. This application was not pressed by the applicant and was withdrawn. Full stop. The applicant then preferred an application on 18/9/2006 for permitting him to insert the verification clause without changing any abetment in the affidavit of evidence. Full stop. This application was opposed by respondent number 2. Full stop. After hearing the parties, the Metropolitan Magistrate has rejected the application preferred by the applicant. Full stop. Para. Aggrieved by this decision of the Metropolitan Magistrate, the applicant has filed the present criminal application under Section 482 of the Criminal Procedure Code. Full stop. The petitioner had also preferred a civil revision application against the order of the Metropolitan Magistrate, which was dismissed by the Sessions Court as the order impugned was interlocutory. Full stop. Para. The learned advocate for respondent number 2 raised a preliminary objection regarding the maintainability of this application. Full stop. He submits that the present application amounts to a second revision and therefore, it ought to be dismissed. Full stop. Several judgments have been relied on by the learned advocate on this issue. Full stop. Para. However, a perusal of the order of the Sessions Court indicates that the revision was dismissed on the ground that the court had no jurisdiction in view of the fact that the order impugned was not a final order but an interlocutory order. Full stop. Therefore, the submission raised by the learned advocate objecting to the maintainability of the present application under Section 482 is unsustainable. Full stop. Para. The learned advocate points out that under the Oaths Act, Section 7 provides that an omission or irregularity of an oath or affirmation would not invalidate a proceeding or render admissible, evidence in respect of which such omission or irregularity has occurred. Full stop. Para. In the case of Nandakumar Shankar Mahatra versus Dayanand Mahadev Mahatra and others, 1989, (1) CR 112, wherein he was taken the view that an affidavit without a verification clause or a defective verification cannot be admitted in evidence by relying on the judgment of the Supreme Court. Full stop. The Supreme Court, in the case of Associated Journals Limited, was dealing with a company appeal filed from a company petition. Full stop. The Supreme Court held that if an affidavit has some defect or irregularity, the same can be cured by giving an opportunity to the affiant to rectify the same. The court observed that the rules of procedure cannot be a tool to circumvent justice. In the case of Nandakumar Mehtra, Supra, the learned judge has opined that a party cannot be permitted to amend the affidavit which has already been filed by him. As such, an affidavit cannot be amended. The learned judge has placed reliance on the decision of the Supreme Court in AKK Nambier's case Supra. The Supreme Court has observed that in essence abbreviation is required to enable the court to determine whether it would be safe to act on such an affidavit of evidence. The court then discarded all the affidavits as they lacked a proper verification clause. In view of the decision of the Supreme Court in the case of Associated Journals Limited, Supra, I am of the opinion that the application filed for including the verification clause must be allowed. It is a curable defect and the court can permit the applicant to insert the verification clause in the affidavit of evidence. The application is allowed. The applicant shall insert the verification clause in the affidavit filed by him within 2 weeks from today. No other changes, corrections, amendments, modification in the affidavit will be permitted.